We're now moving on to formation of contract. This is lecture 2 in the series that we are looking at in the course Construction Law, LQB 7006. Now, when you're talking about formation of contract, as we have seen, a construction contract is made up of different documents, and it is the contract there. Sometimes it can also be a pre-contract agreement. It can also be, for example, drawings, and also some pre-tender works that need to be done, which then brings us to the tender process. So normally, before a project is given to someone, we have what is called the tender process. They will have to go through this tender process because the term tender is important in construction contracts as in many other business contracts. It is an offer by a contractor. Usually, it'll be in competition with a few others who are also submitting tenders for the same project. And if a particular a tender, is accepted by the employer, then it becomes a binding contract. The tendering process is defined as a process where a contractor has made an offer to the employer to carry out the works according to the tender document. And if a contractor accepts, if an employer accepts this contractor, then the contractor is selected to carry out the work on the basis of settlement of an offer on which a contract may be led. There are therefore various tendering methods which are important. And one of the important and most transparent of all is the open tender. An open tender makes public tenders much more transparent. It is a process where an invitation to treat, i.e., the employer puts out this tender notice to the world at large. It's an invitation to treat. It is not an offer. But when someone picks up the invitation to treat and then he submits an offer and the client accepts the offer, it then becomes a contract. So it is a process where the invitation to treat is made to the world at large for the submission of offers, for the carrying out of specific works, therefore leading to a bilateral contract. Secondly, we also have what is called selective tendering. What is selective tender? It restricts the number of tenderers being invited to submit the bids. It becomes a specialized contract. It is something very special. Not every contractor will be able to submit the bids. Only a limited number of contractors are pre-qualified or pre-selected, either from an approved list or an ad hoc list that has been drawn up taking into account all the latest specialized contractors who are selected to apply for this particularly specialized contract. Then we have negotiated tenders. This goes on the basis of negotiations. It involves direct negotiation and therefore no competition. It is frowned upon as being less transparent and that preferred contractors may be given preference over genuine contractors who are really skilled to perform the works. So there is no competition. It is said to be a contract based on negotiated price rather than being awarded as a result of competition. It normally, well, sometimes it has been said that normally it involves a few preferred contractors, which is not truly accepted in a transparent tender method. Then we have what is called the joint venture tenders. These are joint ventures, i.e., the consultants, the contractors undertake, they work together. Consulting company and the contracting company will work together, and they undertake the design and implementation of the project as a joint venture through the setting up of a joint venture company or by entering into a joint venture agreement. So here you'll find there will be more contracts behind the scenes. There will be a contract between A, the contractor, and B, the consulting company. Together, they enter into a contract called the joint venture contract. And then this joint venture contract, then they approach and they submit the tender together as one entity to the client. And then you find you have then the contractor, the joint consultant, and the client. Although it looks like three parties, but in fact, it'll only be a two-party contract, i.e. between the client and this joint venture partners. So, having looked at tenders and the various types of tenders that we have, we also have something called the letter of intent. What is a letter of intent? It is an intention, all right? It expresses the intent of the client to award the contract in question to a particular tenderer. In other words, prior to the formation or drawing up of an official contract between the client and the contractor, and they want to make sure that, well, you really want to make sure the contractor doesn't run off somewhere. You've accepted his tender, but there is still nothing solid. And you still don't want to wait until the contract is drawn up because it could be a long time, could be a long process. So what you will do is give a letter of intent. So in this letter of intent, an employer will then identify any issues requiring further clarification, such as technical information or design issues. The necessity for further, the letter of intent is there. We intend to give you this contract, but we also want to clarify these matters. The necessity for further negotiations on matters relating to scope of work, and also the need for rationalization of prices. Sometimes currency fluctuations, sometimes certain materials may need to be changed due to the unaffordability of the price of that original material, which has now escalated. Any other relevant matters or other conditions that need confirmation. Also, in the letter of intent, there may be a timetable or a time frame to resolve the above issues. That means all of these issues, we have these issues and we have started now. The letter of intent is dated this and dated that, but we're going to settle it all by whatever date. The issuance of the letter with all of these there will not be tantamount to an acceptance, as it does not give rise to any legal rights or obligations. So, but we have cases, and we have looked at some of these cases during our lecture hours. So I want to leave you with these questions. Discuss the legal implications of a letter of intent issued in a construction contract. What if there are mistakes in the tender? What are the consequences? and discuss the problems associated with formation of contract. How have courts construed the terms in a construction contract? What issues have come up with respect to implied contracts? Thank you.